Okay, so we're recording. If you guys feel like you are missing anything or you need to go back to the lecture, I will be posting the video of today's lecture. I'll be attaching it to today's assignment by the end of today. Okay, so repeating what I said earlier, the 14th Amendment has been used a lot because of its language. And specifically, the language that is important for the 14th Amendment is its elements towards citizenship, legal protection, and the right to trial. Again, the language that is important is the way that it relates to citizenship, legal protection, and the right to trial. So now we are going to look at segregation. Segregation is officially considered constitutional in Plessy versus Ferguson in 1896 because of this idea of separate but equal. So you guys should have that first bullet written down on today's slide. Plessy versus Ferguson is 1896, and it declares that segregation is constitutional as long as it is separate but equal. But when we dive into the Jim Crow era, we know that these laws are anything but equal. So while they are definitely separate, they are absolutely unequal. In one way in this Jim Crow era that these issues are unequal is specifically looking at the education system. So an example, if you want to write this down, it's up to you, but it's an example where we actually see this separate but unequal practice is in South Carolina, where about $150 is spent on a white student, $40 is spent on a Black student. So while yes, they are separate, they are clearly unequal because one group is getting more resources than another. Now, something that is important to know is that these segregation Jim Crow laws are based within the state. So they are state-based laws. So every state in the South mandated school segregation. So again, every state in the South mandated school segregation. But there are 10 other states outside of the South that either permitted or required school segregation. So while yes, this is mostly in the South, it is not only in the South. So you don't have to write down the slide. This is just an example. You guys can see in the South, the dark red, the maroon is where they required segregation. These orange states, or these like more true red states, segregation is optional. In white states, it doesn't say whether or not segregation should be allowed. But then in these coral states, that is where segregation is actually outlawed. So when you look at the amount of states that actively push against segregation, it is a very small list. So now, the case that completely changes segregation is Brown versus Board of Education. Brown versus Board of Education is in 1954. And in the story of Brown versus Board of Education, you don't have to write all this down. I'm just going to give you guys some clarity as to what it is. Linda Brown was a third grader, and she was required to go to a school for Black children in her hometown of Topeka, Kansas. So in order to go to school, to go to this all-Black school, Linda had to walk 6 blocks, crossing dangerous railroad tracks, and then getting on a bus to take her to her required elementary school, even though there was a very close elementary school to her that was attended by only white children. Her father was very frustrated with this, obviously, and he was encouraged by the NAACP Chief Counsel, Thurgood Marshall, who's actually going to become a Supreme Court Justice, to sue Topeka School District. So the case is named after them. So the Brown family versus the Board of Education in Topeka, Kansas, and they have a unanimous ruling against segregation. So all 9 Supreme Court justices rule that separate is inherently unequal. I see your question, Kayla. Give me 1 second to double check. Because I know who Ruby Bridges is. I'm also confused, but Ruby Bridges is not involved in Brown versus Board of Education. So yes, she is a notable child when it comes to desegregation, but it's in a different realm. So we have 1954 unanimous ruling against or ruling for the Brown family. They decide that separate education facilities are inherently unequal. And as we know, it's a landmark in terms of legal history, and this officially sets up desegregation. So now we're going to look at the role of Thurgood Marshall and the NAACP. So Thurgood Marshall represented Linda Brown and her family during Brown versus Board of Education. And it's important to know, so first, sorry, I'll give you guys a second to get your slide set up. We're looking at Thurgood Marshall and the NAACP. He's the NAACP's chief counsel, and he represents the Brown family in Brown versus Board of Education. Now, when we say, looking at the slide, test cases, what this means is the NAACP had been frequently looking for cases to try to bring to the Supreme Court to help end segregation. So they have these different test cases to try to argue for why segregation, especially in education, is inherently unequal. Now, the reason why they end up using Linda Brown and her school, Monroe Elementary, as their main case is because Monroe Elementary was not underfunded. Like, Monroe Elementary was actually getting the funds that they needed. So what this meant is they could actually argue the issue of segregation as a whole. So if they are, you guys don't have to write this down, but if they chose a case where one school was inherently underfunded, then it would raise the question of, oh, okay, so we can still be separate as long as we give everybody equal money, which obviously isn't the point that they're trying to make. So they need to choose Linda Brown and Monroe Elementary because it allows them to look specifically at this issue of segregation and not just like trying to put not allow the Supreme Court to try to ignore that piece. So, and one of the ways that they argue against segregation, even if the facilities are equal, is through the work of Kenneth and Mamie Clark in their Clark doll test. Kenneth and Mamie Clark are two psychologists that Brown uses in his argument. Kenneth and Mamie Clark argue that separate but equal does immense damage to Black students' self-esteem. And so even if the school has funds and has the money that they need, school segregation reinforces these notions of differences and inequality. Any questions about Brown versus Board? Okay. All right, so now we're going to look at the impacts of Brown versus Board. So as we've already said, separate. What Brown versus Board shows is that separate is inherently unequal. And so what this does is it overturns the Plessy versus Ferguson precedent. So again, Brown versus Board overturns Plessy versus Ferguson. And they overturned Plessy versus Ferguson by zooming back in on that 14th Amendment. And I'll tell you what Chief Justice Warren says. Chief Justice Warren is the Supreme Court leader at this time. Chief Justice Warren says that school segregation violates the 14th Amendment's Equal Protection Clause. So again, Chief Justice Warren says that segregation violates the Equal Protection Clause. Now, what's important to know is that this is not the end of segregation. This is a starting off point. And we actually see a Supreme Court decision called Brown 2. So this is a follow-up to Brown versus Board of Education. So the Supreme Court knows that desegregation is going to be vastly unpopular. So in this decision of Brown 2, the Supreme Court declares that you must desegregate with deliberate speed. I apologize, just to back up, this is in 1955 for Brown 2. So again, Brown 2 is in the summer of 1955, and they agree to desegregate with deliberate, and the Supreme Court tells these schools to desegregate with deliberate speed. But now the question is, what does deliberate speed mean? And this becomes a controversy. So again, this is where we have this dispute, is what does deliberate speed mean? And white racist Southerners begin the massive resistance campaign. The massive resistance campaign is the campaign against integration. So again, the massive resistance campaign is against integration. And as we know, the civil rights movement does not end here. So the massive resistance campaign is successful. And the other caveat to know about Brown versus Board is that this only ends segregation in public schools. So again, Brown versus Board of Education only ends segregation in public schools. Okay, guys, we have a few more slides, but we're through all the really long ones. So a few more slides, but we're through the big ones. So now we have Brown versus Board. The Supreme Court has said that separate but equal is not constitutional. Now, how do we increase this impact? And as we know, one of the leaders of the civil rights movement is Martin Luther King. And one of his biggest pieces against segregation is the letter from Birmingham jail. So you guys know, if you want to put a star or highlight letter from Birmingham jail, this is your last required foundational document for the AP exam. So again, the letter from Birmingham jail is the last required foundational document for the AP exam. In the letter from Birmingham jail, King uses a lot of language from the 14th Amendment. He very much references the 14th Amendment in the letter from Birmingham jail. And in the letter from Birmingham jail, he encourages those who are neutral to take a stronger stand against segregation. And we're going to see segregation continue to slowly end. And this really begins with 3 different laws signed by President Johnson during his presidency. So we're going to go very quickly over these 3 laws. So again, we're going to go into more detail about these 3 laws. First, we have the Civil Rights Act of 1964. Here's what I found. Sorry. I don't know if you guys can hear my watch. Okay, so Civil Rights Act of 1964, it outlaws public discrimination. So yeah, Civil Rights Act of 1964 outlaws public discrimination and increases employment opportunity. Next up, we have the Voting Rights Act of 1965. The Voting Rights Act of 1965 outlaws poll taxes, and just in terms of context, it's important to know that the Voting Rights Act is what leads to the Selma March. So I'm sure you guys have heard of the Selma March. That is actually because of the Voting Rights Act of 1965. And finally, we have the Housing Rights Act of 1968, which bans discrimination in housing applications. Okay, everybody, we have 3 more slides, so we're going to try to get this done quickly. Okay. Next up, so we're going to take a quick transition from the civil rights movement that we all know and start looking at a couple other ways that the 14th Amendment and the equal protection of citizens has been expanded. So first, we're going to look at the women's rights movement. And I'm just going to quickly go over these different little bullets so that way we know what they are in terms of the women's rights movement. So first we have the 19th Amendment. The 19th Amendment gives women the right to vote or protects women's right to vote. And the 19th Amendment is passed in 1920. We have the creation after the 19th Amendment of, or not after, it's not right after, give me 1 second. I just need to confirm my date. So NOW stands for the National Organization for Women. Again, NOW stands for the National Organization for Women, and it's founded in 1966. So again, now National Organization for Women is founded in 1966, and they are an organization similar to how the NAACP looks out for the civil rights of Black people in the United States. Now is focused on protecting the civil rights of women. Just a few other quick key terms. The Equal Pay Act is passed in 1964. And the goal of the Equal Pay Act is to ensure that people get equal pay regardless of their gender. The women's rights movement continues with Title IX, which you guys can see as the fourth bullet. Title IX is a law that provides women equal opportunity of participation in sports and colleges. Again, Title IX provides women equal opportunity of participation in sports and colleges. As we know, Roe versus Wade protects a woman's right to choose. But something that's important to know is that we still do not have an equal rights amendment for men and women. So the Equal Rights Amendment is an amendment that is basically the women's version of the 14th Amendment, but it still has not been passed. So there still is not an amendment that is protecting women's civil rights explicitly. Two more slides, my friends, and then we are done. So now we are going to look specifically at the fight of the LGBTQ community and towards ensuring their equal rights. Now, it's important to know that until 1973, homosexuality is considered a mental disorder. So that's where we're starting. So in 1973, homosexuality is finally removed as a mental disorder by the psychiatric community. In 2003, we have Lawrence versus Texas. And in Lawrence versus Texas, it makes it possible, or it removes a state's ability to claim homosexuality is illegal. So before Lawrence versus Texas, many states had same-sex activity illegal, or they claimed it was illegal. There's also a lot of discrimination against homosexuality in the military. And one of the official policies in the 2000s is don't ask, don't tell. And don't ask, don't tell required people in the LGBTQ community to be closeted in the military. So if you were in the military during the time of don't ask, don't tell, you were required to remain in the closet. And this isn't overturned until 2010. So those are some different ways that the LGBTQ community is discriminated against. Now we're going to look at marriage, or the right to marriage. So DOMA, D-O-M-A, stands for the Defense of Marriage Act. DOMA is signed in 1996. And DOMA ensures that states don't have to honor marriages that are completed in other states. So in 1996, if you get married in a state that allows gay marriage, but then you move to a state that doesn't, then your marriage would be considered like not real in the eyes of that state. DOMA is officially overturned in Obergefell versus Hodges. Obergefell versus Hodges was in 2015, and it officially creates marriage equality and requires that it be allowed in every state. But as we know, in terms of fighting for equality within the LGBTQ community, there is still a lot of ground to be made. So for example, there is still this debate of religious refusal do you protect a person's equal protection of just because they're in the LGBTQ community, they still have equal protection under the law, or do you recognize freedom of religion? So so religious refusal continues to be a big debate. And more recently, we are starting to see a larger movement towards transgender equality and transgender protections. And with that, my friends, we are going to stop our lecture because we have about 6 more minutes. Just as a reminder, today's lecture notes are half of today's class grade. So as you guys can see, we basically skipped the do now. The exit ticket is just 3 multiple choice questions. So you can either like comment and tell me what answer you're choosing, or you can highlight the correct answer. It can be whichever way that you prefer, but it is page 3 of today's classwork. That is the only part I'm going to be looking for to make sure it's done. So once you complete your exit ticket and you submit photos or attach a file of your lecture notes, you guys are free to go. Please do not leave until you do both of these things. I also need to take attendance. So if you sign out within the next minute, you will not be marked as present in class. So make sure you give me a second to take attendance. I'm going to put those 2 things in the chat so you have them. Again, make sure you guys are 1, completing your exit ticket, and 2, adding either the attachment of your notes or pictures of your notes. Once you do both of those things, you guys are free to go. I will also not be marking, I won't be marking work as late. So just got your text, Samaj, that's fine. So I will not be marking today's assignment as late until 4:30. So as long as you guys submit your work by 4:30, you guys are good. I will also be having office hours, and it'll just be open from 2:40 to 4:15. So if you need help with anything, feel free to hop in there as well. Just know I'm looking for those 2 things, lecture notes and exit ticket. Awesome. Shakeem, I have all your stuff. You are free to go, my friend. So once I see that you guys have submitted both of these things, you guys are free to go.